Can self-defense go overboard? When dealing with self-defense, everything has to be reasonable. We've already talked about in other videos, you have to reasonably believe that you have to use force, and that reasonableness is both a subjective standard, did you believe self-defense was necessary, and it's also an objective standard, would a reasonable person believe self-defense was necessary? And so it's no surprise that you actually have to use an appropriate or reasonable amount of force when responding to a potential aggressor. And so the state of Indiana, the Court of Appeals, love to talk about multiple shots undercut a self-defense claim, saying if you shoot too many times, well, you can't argue self-defense. That is not the law. That is not the law at all here in Indiana, at least. And anybody that watches the news or watches YouTube, we're seeing more and more body cam footage. We're actually seeing police officers, how they engage use of force. They fire multiple shots, 3, 4, 5, 6, until the person is no longer a threat. And when you see law enforcement say multiple shots undercuts a self-defense claim, it's just laughable because police do exactly that, multiple shots. The reality is the law in Indiana is clarified by the Indiana Supreme Court in a 2020 decision. Says you can't shoot somebody after they've already retreated or no longer a threat. And so what that means in practical terms are, the Indiana Supreme Court gave us multiple examples going back almost 50 years of how to interpret this. But, if somebody has their hands up in the air and you continue shooting them, that's going to be the problem. You're not going to be able to claim self-defense. Another case, people broke into a man's house and the man shot them. That's self-defense. Then the man proceeded to get a knife and chop them up. That man lost self-defense. He went overboard. If someone's running away and you shoot them in the back, again, you went overboard. There's another case where somebody shot 23 times and there was no evidence of a gun or evidence that the other person fired a gun. So it's like extreme situations, but the reality is you can fire a gun until the person's no longer a threat. But once they're on the ground, if they're on their knees or laying face down or their hands are up or they're running away, you can't keep firing at them. That's the standard here in Indiana. And I will say, from practical purposes, from doing cases where people use the self-defense, deadly amounts of self-defense, and I talk with the jurors afterwards, the issues the jurors consistently have. Did the person really have to fire so many shots? Even though you're allowed to use as much force until the person is no longer a threat, just from a perspective of trying to convince a jury, the less is better. Obviously, if you feel threatened by someone, you have to use self-defense until they're no longer a threat. There's no argument there. But if the state of Indiana chooses to charge you, as they can, even if you're like, hey, I self-defense, this is pretty good. Look at the guy had a gun, he came at me. The state of Indiana can still charge you. And if you hire me, I have to convince a jury that you use the appropriate amount. And so even though the cases say that you can shoot until there's a threat, it's an easier job for me as an attorney to help a jury find my clients acted in self-defense if they don't fire multiple rounds. So just keep that in mind. And, I can't stress, if you're in a situation where you are dealing with self-defense, please plead the fifth until you're able to get an experienced attorney to go with you, talk with the police. Probably not even going to do that, but the less you say, the more opportunity you have. The worst thing that could happen, they catch you in a small lie. What did you have for breakfast yesterday? I had oatmeal. Here's a picture of you eating an apple. You're a liar. You lied about self-defense. You lied about your breakfast. That sounds crazy, right? That happens every day in this state. Remember, the amount of force you use has to be proportionate to the threat, and you can't go overboard or you will cause problems and you might even lose that self-defense claim. And then from a practical purpose, trying to convince a jury, the fewer shots, the easier it's going to be to help that jury find self-defense and the person is not guilty. If you have any questions, give us a call, 317-632-3642. Remember, always plead the fifth.